Community Law. I am the department head for the litigation department, and we are going to dive into, yay, we got a judgment, now what? Quick little housekeeping things. Sorry, I'm going to have to read off a page here for a second. So on your screen, you'll see the PowerPoint presentation in the center of your screen. This should take up most of the screen. There should also be a small box on the bottom right-hand side of the screen with the video feed. That should have my face on there. On the left side of the menu, please select the questions and answers icon and type all your questions there, which will be addressed at the end of the webinar. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report, and those will be sent via email within 48 hours following the webinar. These credits are non-transferable. Please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about receiving your CMCA certificates. All right, with that, let's dive into this. So first couple things, just some disclaimers. We are simply providing information. I'm not providing any legal advice. We try to be irreverent and humorous, but it's not meant to offend anyone, so hopefully that does not take place here. Additional resources, as always, our website is a great spot to look up articles on anything, but there's a lot of stuff about litigation matters, obviously transactional things, policies, things that are just going on in the HOA world, so it's always a great place to look. Also, if you're not signed up to our website for our blogs and newsletters, please do that. There's a bunch of good information that's going out on all of the pressing issues of the day. So hopefully you guys are on there. We're also on Facebook, Twitter, LinkedIn, so you can go to any of those kind of basic ideas. Looks like we have about 100 people, a little more than 100 people on here, so hopefully this goes smoothly for you guys. All right, so there's four kind of basic files that we handle in the litigation realm. I mean, from a general idea, litigation is going to encompass debt recovery, foreclosure, covenant enforcement, and then what we just term as kind of litigation in general, which are going to be your kind of insurance defense issues, things along those lines. Debt recovery is its own department, but if you're looking at it in the broadest sense, what they're doing is litigation as well. It's just a different department because we have so many different files that go on over there. So we're going to talk about debt recovery first, and then we'll go through foreclosure, then we'll go through covenant enforcement, and then we will go through litigation. So each of these will kind of go with a little brief overview of how the process works with each type of file, and then we'll kind of go through what your post-judgment options are once you've gone through all the process. So first things first, we'll go into debt recovery files. First thing that you need to do with any debt recovery files, we need to make sure that there's a collection policy, and that collection policy is up to date. As with anything, any kind of policy that the association has, we want to make sure that the collection policy is enforced evenly. We don't want some owners to be getting late fees and others not to be getting late fees. If they're both delinquent, they should both be getting the late fees. They should both be getting the interest, if that's applicable as well. Next thing that we're going to look at is we're going to make sure that there is a payment plan letter that's required by statute. In addition to that, most of your enforcement policies, your collection policies, are going to also have lien provisions. And sometimes it's the management company that files the lien. Sometimes it's our firm that will file the lien. It just kind of depends. It's kind of important to know about liens. There are two different ones that come into the debt recovery realm. You have the statutory lien, which is a creature of statute, doesn't need to be perfected. Simply once an owner becomes delinquent, that lien attaches to the property. There's nothing the association has to do. There's also a second lien in most of your guys' documents. That's going to be created by the declaration. With that one, we do need to file the notice of lien, and that's typically what you guys are doing or we're doing when it comes to our office. You file that notice of intent to lien, advising anyone who is going to purchase this property that there is a lien and that needs to be taken care of. Once the payment plan letter and the lien have been taken care of, the next step is that the file would be turned over to the attorney at whatever amount the collection policy says. So some of your policies may say that it's 4 months delinquent. Some might say 6. Anything longer than that can be a little bit problematic. We want to get these over as quickly as possible because the lower the amount is that we're trying to collect on the debt recovery side, the easier it is for a homeowner to have the ability to come up with those funds. So obviously, if it's getting turned over and they are only owing $600 or $1,000, that's a lot easier for a homeowner to come up with than if we've waited years and now we're trying to collect $4 or $5 grand. It's a little harder for that owner to come up with that amount on a quick turnaround. So that's why we try and get these things over as quickly as possible. Once the file is turned over to counsel, the first thing we're going to do is a title search. We want to make sure who the actual owner is of the property. Sometimes the letters that you have sent out are only going to one owner. So you may be contacted by that recovery team talking about we need to send out at least an additional letter to any other owners. Sometimes there's been a quick claim we didn't know, things along those lines. So that's why a title search is needed. It might be as simple as we're going on to the assessor site to see what they have. It might be, if it's more complex, we might have to actually pull a title report. So it just kind of depends. We're also going to be looking at bankruptcy. We want to see if the owner has filed bankruptcy, either Chapter 7, Chapter 13. If they're an entity, maybe it's Chapter 9 or Chapter 11. But because bankruptcy puts different provisions on the association and on us as debt collectors, that's something we need to do and determine whether or not what our next step is best. If there's a stay on it, then we'll advise you of what the next best steps are for the association. We're also going to do a PT search or a public trustee search. That's to see if the bank, whether first mortgage or a second mortgage, has started any type of foreclosure. If they have, the DR team will reach out to you and kind of advise you of what the next best steps are. Once we've run those searches, the next thing we're going to do is send out a 30-day demand letter. This gives the owner an opportunity to reach out to us before we file a lawsuit and either enter into some type of payment plan or pay the amount in full. Sometimes when we send those 30-day demand letters out, they will do what's called a debt verification request. And ultimately what we need to do when that happens is we put things on pause briefly just to get them a current ledger. We'll provide them with that ledger, and then we can move forward with our action if they don't enter into any type of payment plan. The DR lawsuit. So when you're talking about a debt recovery lawsuit, we're talking about a judgment for money, so money judgment. So we'll draft that lawsuit. The lawsuit will say how much is owed at that given time. It'll include our attorney's fees. It'll include late fees, interest. Obviously, that's for that current date. The next day, the amount may have changed. A new assessment may have hit, etc. So that oftentimes we have owners contact us and say, I'm willing to pay the lawsuit amount, but they've not contacted us for maybe 1 or 2 months. And so the amount has changed. And so we have to provide them with an updated amount. Once we've drafted the lawsuit, we'll get that out for service. We'll serve the owners personally. Sometimes we can serve them through a spouse or someone else who's living at the house. So kind of service can depend, but we'll get that out for service. Once service has been obtained, the next thing is a return date or summons will be set with the return date for the owner to show up at court. They can either show up at court that day or they can file an answer previous to that date and they don't have to show up. If they fail to either show up or file an answer, we will then request default judgment, which the court will typically grant. If they do show up, we'll try and work with them and get a payment plan in place. If they don't do a payment plan, then the next step is they would file an answer. Once the answer is filed, in most courts, mediation is going to be mandatory. So we will set mediation. Sometimes it'll be through a court-appointed mediator. Sometimes it'll be through a private mediator. We typically try to use private mediators because they have a better understanding of HOA law. And so we use a couple of different mediators in general, but there's lots of mediators that can do it. When you're at mediation, one of the things that you will hear about in terms of settlement are the soft costs. And so those are going to be your fines, your interest, and those are things I use ultimately to reach a settlement. I mean, those are costs that the association is not out. And so they're usually good bargaining tools to try and get the owner into a payment plan and get the association some money. If we are not successful at mediation, the next step is we're going to have a trial. So sometime before the trial, your attorney will reach out to you as the manager and any other witnesses, and we'll do kind of a basic prep of just going over here are the kind of questions we're going to be asking. here are the things you should be prepared for. If there's opposing counsel, we'll try and get you prepared for what questions they might be asking. And then the next step is we go to trial. So at trial, we're going to be putting our case on. We're going to be showing to the court why, in fact, the association is in the right, that these owners have not paid for however many times. Maybe they've made partial payments. Maybe they've paid all the assessments, but they haven't paid the fines or the attorney's fees. And so we have to kind of walk them through how these funds are applied and things along those lines. So we'll go through the trial, and presuming that we've done our job properly and that we have all the proper documentation, a judgment will be issued for the association. So it's important to remember that that judgment is for a specific date. So if the judge issues the judgment on March 1st, and we've submitted what we think is owed as of March 1st, and they grant that, anything that comes due after that March 1st date is not part of the judgment, and therefore is not something that we'd be able to collect through that judgment. Now, oftentimes, once we have the judgment, we'll be able to get the owner onto a payment plan that is for an amount that's greater than what the judgment is. But if the owner is only willing to enter into something regarding just the judgment or just pays off the judgment balance, then the next step is we'd have to file another lawsuit and start this over again to collect those additional dues that were owed after the judgment was attained. So in terms of collection type options for a debt recovery file, the main ones that we use are going to be a bank garnishment or a wage garnishment. A bank garnishment is a one-time hit on an owner's bank account. There have been a few things that have made this a little more difficult during COVID times. The first thing is that now, and it's going to be good, I believe, through June 1st as of right now. It was originally good through November, got extended to February, and then it's now been extended again through June. But the first $4,000 of anyone's bank account is not touchable. So in order for a bank garnishment to be successful right now, we have to file the bank garnishment, and the owner has to have more than $4,000 in their bank account. So if we have say we have a $2,000 judgment, and we do a bank garnishment, and the bank responds back to us and says that the owner has $6,000 in their bank account, that first $4,000 we can't touch, but that entire remaining amount of the $2,000 will be held, and we can go ahead and collect that through them. There's a couple more steps that we'll have to do. We have to serve the bank. We have to serve the owner. The bank will then notify the owner that these funds are being held, and the owner has the ability to contest those held amounts and basically object to us trying to take them. Typically, though, once we serve a bank garnishment and the funds are being held, the owner is going to reach out to us. And so because they have funds now they can't access, they will reach out to us oftentimes before we even know the funds are being held, before the bank has let us know. So bank garnishments can be good, but as of right now, because of that $4,000 hold, we don't do a ton of them unless we have really good information that these people do have a large amount in their bank account. The other option that we use most often is a wage garnishment. This is a garnishment on where the individual works. So these run for 6 months, and ultimately we will get a portion of their paycheck. If they're getting paid once a month or twice a month, we'll get a portion of that up to 20% to be applied towards the judgment, and that'll keep going until the judgment is satisfied. If we get past that 6 months, then we would renew that wage garnishment and start over until we get the full collection of everything that is owed to the association. So wage garnishments are still going right now. They're probably our number one collection tool in the debt recovery department at the moment. So they are a great thing, and we keep working with those every day. Other things that might come into play in terms of collection options are receiverships. So we may ask the court to put a court-appointed receiver into the property. Ultimately, what that means is they basically become the landlord. And so that individual will go in and they'll collect rent. They will pay themselves as the receiver, and then the additional money will come to the association until the debt is paid down. Now, receivers only work if the property is rented or if it's vacant. So if it's owner occupied, we're not going to be able to do it. If it's a family member that's living in the property, we're also not going to be able to do a receivership. Other tools that we have in terms of collecting is acceleration. So this is really kind of a pre-judgment kind of thing, but at the beginning of each year, it's a great time to look documents allow you to do an acceleration. If they have an acceleration clause and you have a owner who is delinquent, ideally we want to accelerate that entire year worth of assessments. And then when we're filing our lawsuit, we're doing it for a greater amount. So if we file the lawsuit in February, we're collecting all of 2021's assessments at that time, or getting a judgment for it. That then would give us until the end of 2021 to collect that amount on the judgment, and get the owner caught up. If we don't do the acceleration, and we can't get them to a payment plan, we're just collecting the judgment. So say we got the judgment in March and we finish collecting on that judgment in, say, September, that owner's still going to be delinquent from March to September. And so a new lawsuit would have to be started. And so that's kind of where the benefit of acceleration is. If we can have that entire year as part of the lawsuit, then we have the ability to collect it, and get the owner back to a zero balance. So that's ultimately what we're trying to do, is get the association paid as quickly as possible, and as much money as possible. Also, some of your declarations will allow for the association to withhold the use of amenities, or suspension of voting if an owner is either delinquent or if they are in violation of some other covenant. One of the great tools of collecting for the association is if you have pools, and you hand out pool keys. If we have the ability to withhold a pool key, oftentimes when summer comes and little Johnny wants to go to the pool and his parents go for that first time and they can't get in, that is a great driving force to have them reach out and try and get into a payment plan. So that can be a very valuable tool if it's one that is open to you. All right. So that's a quick little rundown of debt recovery. Tied to debt recovery, but at our firm, in our litigation department, is foreclosure. So if we are going through a collection case and we have our judgment and we're just unable to collect, either we can't find a bank account, we aren't able to find where they're employed, and the balance gets high, then foreclosure is often a viable option. Foreclosure is your biggest stick as the association. It's our ability to take away someone's home. So associations don't take that lightly, but it is our biggest stick. So we have the ability to do it. There are some requirements before we can do it. One is that the balance has to equal or exceed 6 months of assessments. So if it's a $100 monthly assessment, the owner must owe at least $600. It doesn't mean that has to be $600 worth of assessments, but there has to be at least $600 owing, whether that is assessments, fines, late fees, etc. We have to at least equal that amount of 6 assessments. Other things that we're going to look at is there equity in the property? So at that stage, we're going to, when debt recovery asks us to do a foreclosure recommendation, or maybe the board asks us or our manager asks us to do it, we're going to look at how much is owed on the house, and we're going to look at what we think the house is worth. Now, granted, these are somewhat rough estimates on what the house is worth. We're going to look at the assessor site to see what they're assessing it at. That's going to be relatively low number. And then we're also going to look at sites like Zillow to see what we think the market value is. And if the first mortgage owes less than that amount, then you're going to have equity in the property. And depending on how much equity there is, maybe it's $10,000, maybe it's $20,000, maybe it's much higher. We're going to put that into our assessment of whether it makes sense for the association to move forward with a foreclosure. We also need to make sure, like with the collection file, that the HB 1276 letter has been sent. We're going to need a zero balance ledger so that we can go back and show exactly how much money is owed. We're going to need to have a collection policy in place again, just like a collection file. And then the board is going to have to sign off on the foreclosure resolution. So when we provide our foreclosure recommendation, we're also going to have a foreclosure resolution there that the board needs to sign off on. They can't do a blanket resolution of say, hey, anytime a property gets to $5,000, we want you to move forward with foreclosure. The board has to look at each file that is being recommended for foreclosure and then make a decision on that specific property, whether they're going to move forward with it. And then they need to document that. So the easiest way is to do that with a foreclosure resolution, which is why we provide it. There are other ways that it could be done. It could be put in the meeting minutes or something along those lines, but the cleanest way is to have a foreclosure resolution. So we had a quick question here from Janet. Under the bank garnishments, when did it go to $4,000 level? If there isn't that much in the account, then can anything be held? When does it get released? Okay, so the $4,000 was a response to the COVID pandemic. and it was done. It originally passed in, I want to say, June of 2020. It was originally only supposed to run until November, but because the pandemic is still ongoing, it then got pushed to February, and then now has been pushed again to June. There is still talk of it getting pushed again, but each and every time that it has been pushed, there's been less and less support for it. And since it seems like things are hopefully trending up, hopefully it will not be continued again. So if someone has less than $4,000 in the account, we can't touch it. That's their money. We can only collect things that are above it. That $4,000, in terms of when does it get released, if you're talking about when does the amount that was above $4,000 that we have been able to garnish, it will take some time because the bank has to be served. Then there has to be, the owner has to be served. And then there has to be a time for the owner to object to that. If they don't object, then the court will issue the ruling allowing the funds to be released. We'll get that to the bank, and then they'll release. I mean, that can take 30, 60 days. It just kind of depends. But if the owner does not object to that amount being withheld, then you should have the money within a couple of months. Hopefully that answered your question on that. All right, so once the foreclosure file, the board has signed the foreclosure resolution and it's turned over to legal, the first thing we're going to do is get a litigation guarantee. This is basically insurance. It comes along with the title report. It's basically insurance for the association that what we have gotten is correct, and that if there is some type of title issue, we can go back to this litigation guarantee and seek to collect those funds from them. So say they left out an owner on the title report. For whatever reason, they pull this up. We're getting the title, and somehow they missed the fact that there's a second owner on there. We go through our foreclosure. We get our foreclosure done. And then the second owner pops up and says, hey, wait, you never served me. This is a problem. We got to go back through all this. We can then go back to this litigation guarantee and the insurance company and say, look, you guys need to fix this problem. Either you need to pay or whatever it is, but you need to figure it out and you need to fix it. So it's not a cost to the association. The litigation guarantees can be expensive, oftentimes over $1,000. So they are an expense to foreclosure. It's one of the reasons why the foreclosure file on that first bill is so expensive. But that is something that we always have to get. Once we have that and we've drafted the complaint, we'll get the complaint filed. We need to serve all of the parties who have an interest in the property. So sometimes that's going to involve a sub-association or a master association, depending on who's bringing it. It's going to involve any of the lien holders. So the first mortgage, second mortgage, if there's any other judgment liens on there, they need to be served. So sometimes we might have 8, 10 parties that we have to serve. So we will go through all of that, get all of the parties served. Oftentimes, if there's a first mortgage on the property, they're going to reach out to us and they're going to do a stipulation to lien priority. As you guys are all aware, with the super lien, we have a super lien in the amount of 6 months that is prior even to a first mortgage. So this stipulation to lien priority is basically the first mortgage. They're going to pay us the 6 month super lien. We're going to enter into a stipulation that says that the association's lien is now junior to that first mortgage because they've paid the 6 months, and that party, that first mortgage, will then get stepped out of the lawsuit. So it's very common. We do it pretty quickly. It's not a huge issue. It's relatively cheap, but it's one of the steps that we go through. After that is done, kind of like with the collection case, an answer is either going to be filed or default judgment is going to be sought. Assuming the answer is filed, then we go through what we already kind of talked about in debt recovery. It'll be a little more involved in terms of the preparation because we're going to be in district court instead of in county court like your typical collection case. So there's going to be more discovery. There's going to be more steps. So if an answer is filed, we'll have mediation. We'll go through it, but then we'll get to trial. Assuming we prevail at trial, the next step is that an order for foreclosure is entered. And then once we have that order for foreclosure, we'll turn it over to the sheriff's office. We also like to do, if we have the ability, a receivership during the foreclosure. Because the foreclosure process is relatively long, it's usually about a 9 to 12 month process instead of more of a 3 to 6 month process like the collection file is. If we can, we try to get a receivership in place at the beginning so that the association has money coming in to help defray some of these litigation costs, these attorney's fees that are going to be racking up during the foreclosure process. There's a question too, going back a little earlier, of where do special assessments fit into the 6-month requirement? Again, in terms of being able to foreclose, it doesn't matter. So if it's a special assessment, a regular assessment, whether it's fines, whether it's attorney's fees, etc., as long as we have met that 6-month threshold of, again, in the example of $100 times 6 is $600, it doesn't matter what that $600 is made up of. So that is the basic answer to that. The special assessments would be added in and be something we're looking at when we're doing the foreclosure recommendation. Does the super lien also protect amounts owed after 6 months is paid, or should the association always file hard liens also? So the super lien is only for 6 months. So the lien that the association has by statute is a bifurcated lien. So we have, say the association's owed $1,000, 600 of that, it's not gonna make sense. So say the association's owed $1,200, so it's $100 a month. The super lien is then $600. The lien for the association is bifurcated in that we have a super lien of $600. That amount sits above the first mortgage. Then you have the first mortgage. Then you have the remainder of our lien. So all that the first mortgage has to do is pay that super lien amount. They pay that, then the super lien is gone, and the remainder of our lien is now below the first mortgage. So that's how that process works. In terms of a hard lien, the hard lien would be that lien that would be associated with the lien that you have pursuant to the declaration. The statutory lien does not require a hard lien to be filed. That's just there as soon as the owner becomes delinquent. So hopefully that answered your question. All right, next part. So foreclosure post-judgment. So we deliver the order to the sheriff. So once we have the judgment, we now actually have to go through the sale process. So the first step that we do is we deliver the order to the sheriff. We'll have to publish that, the sale in a newspaper. The sheriff office will do that. That'll run for 6 weeks, and then we go forward from there. If the owner comes before the sale, he or she has the ability to request what's called the cure statement, and that's simply what is the total amount owed. So at any time prior to the sale, the owner has the ability to pay this in full. We may enter into some type of small, very short payment plan on a foreclosure. Typically, we like to keep those shorter than 6 months because we do have court deadlines in terms of getting the sale done. But we sometimes we'll reach out to the association and see, look, the owner has reached out to us. They owe $15,000. They're requesting a 6-month payment plan of $3,000 a month. Do you have any problem with that? If they don't, we'll enter into that stipulation and we'll go forward from there. Oftentimes, though, the owner's not contacting us until maybe it's a week or two before the sale, and so there's not a whole lot that we can do. They either need to come up with the funds or we're going to go through with the sale. So that happens a fair amount, and it's not uncommon for us to get the large sums of payment the day before the sale. We're going to require that to be usually in certified funds, so they'll bring that into us, and at that stage it's great. The owner's paid and the association's now paid. So that's kind of the ideal scenario. If not, the foreclosure will go to sale. The association will place what's called a paper bid. So the initial bid for the foreclosure will be the amount that the association is owed. So that'll be the initial bid. If anyone else wants to make a bid, so if there are junior lien holders, if there's just an investor who comes in, they will offer whatever amount they want over that initial bid. And then you can have a bidding process, and there could be multiple parties bidding, etc. So say the association's owed 15, an investor comes in, they pay 20 grand for it. That first 15 grand of that 20 will come to the association. The association's paid in full, and that investor will be issued a certificate of purchase. So they will then become, once the redemption rights are done, so the junior lien holders will have the ability to then redeem their junior lien. So that means that they would have to pay the investor that $20,000 plus any interest, and then they would become the owners of it. If none of the junior lien holders redeem the property, then the investor has purchased the property and they'll become the new owner. If no investor comes in to purchase the property and it's the association that wins the bid based on their paper bid, then the association will receive the property. And the association has a couple options. We could attempt to sell the property, which would require us to likely have to make some kind of negotiation with the first mortgage to pay it off, because someone's usually not going to come in and just buy our $15,000 property because there's a first mortgage on there. And they don't want to be subject to that first mortgage who could then foreclose them out. So oftentimes if the association is trying to sell it, we're going to be looking at some type of short sale with the first mortgage and whoever the intended buyer is, and see if we can't work it out. It's kind of uncommon. Well, it's very uncommon for the association to get the property. Usually about 5% or less of foreclosure cases does the association actually get the property. With our economy right now and with the housing market, investors have been buying these up hand over fist. So it's very rare that the association gets to begin with. It's even more rare that if the association does get it, that the association tries to sell the property. What is more common is that the association tries to rent it, recoup the amount that it's owed until the first mortgage starts their own foreclosure. It's important to note that the association is not responsible for paying the first mortgage any amount of money. That's a contract between the original owner and the first mortgage. But the first mortgage will eventually realize they're not getting paid and they'll start their own foreclosure. So we want to get someone in there as quickly as possible to rent it out and try and recoup as much money as we can. Association also, if they have a ton of money or have a fair amount of money, they might want to buy the property and use this as either an investment or maybe this is a condo and we want to use this property as a place for almost like a hotel room where our members can use this if they have someone coming and we can rent it out that way. So sometimes buying is an option. It does happen from time to time. The other option is that the association doesn't want to dump any more money in it. And so they'll just simply wait for the first mortgage to go forward with their own foreclosure. Typically, like I said, the usual process is the association will try and rent it out. One thing to know once we have the property is the association is responsible, because they're the owner, of insuring that property as well as paying the assessments on that property moving forward. So those are things that you have to keep in mind when the association gets the property. But that is the basics of kind of how the foreclosure process works. Again, post-judgment there's not that much because we either have the property or we're paid in full. So there's not a whole lot of collecting that has to go on after that. Next type of file that we deal with are the covenant enforcement files. Again, like the collection file, first we want to make sure you have a covenant enforcement policy. Again, we want to make sure the enforcement of that covenant enforcement policy is being done evenly. The most common defense that an owner brings up when we bring a covenant enforcement lawsuit is that selective enforcement, that the association is enforcing against me differently than they're enforcing against my neighbor or someone else within the community. Through that enforcement policy, you're going to provide the owner a courtesy letter, and then the fine, however many fine letters are prescribed in that enforcement policy. You need to make sure that before any fines are being issued, that we are providing notice and opportunity for a hearing before each and every fine. So we send the courtesy notice, then we send the next notice, which is going to be the first fine letter. That fine letter needs to say that the owner has 5, 10 days, whatever's in the policy, to request a hearing. If the owner fails to request a hearing, then after that 10 days is up, we can put the fine on the ledger. If the owner does request a hearing, though, we need to have that hearing. We can't issue that fine until the hearing has been given. So that's the process. And then if you get to the second letter, that same process has to be followed. If they requested a hearing on the first one and they request a hearing on the second one, we still have to give them a hearing. If they failed to request a hearing on the first violation but are requesting one on the second one, then we need to give them one for the second one. So before each and every fine, we got to make sure we give them that notice and opportunity for a hearing. Once you've completed your enforcement policy, the next step is to turn the file over to the attorney. And we're going to go, and what we're going to try and do is get enforcement of that covenant. We're going to file a lawsuit for injunctive relief. So this is different from the money demand that is going to happen with the collection. Here we are asking the court to issue an order that requires the owner to come into compliance with the declaration. So we're not going after, we don't in our enforcement lawsuit collect your fines. We are simply looking for a judgment from the court that says the homeowner needs to paint their house in a proper color. We are also going to seek our attorney's fees through that, but we're not going to seek any past due assessments, nor are we going to seek any fines or late fees or interest. So that's an important distinction to remember with the covenant enforcement lawsuit. Typically, if there's a covenant enforcement issue and it gets turned over, we recommend that the covenant enforcement issue be dealt with first, and then any collections matter to be handled after that. The reason for this is If we are simply just going with a collection lawsuit to deal with a covenant enforcement issue, and so we're just collecting the fines, we might be able to collect 5 fines and say $500 worth of assessments, and the owner, we get that judgment and we collect on that judgment, but the issue hasn't been resolved. So these fines are now, the owner's still getting fined. So now they have, instead of 5 fines, they have 10 fines, and the problem hasn't been resolved. So typically going with just a collection matter isn't going to resolve the covenant enforcement issue. That's why we go forward with the covenant enforcement lawsuit first, so we can get the issue resolved. Once we get the judgment done, then we can turn that over to collections or to foreclosure to collect on the amounts that are owed. But ultimately, we first want to get the enforcement issue done. So the first step that we're going to do once a collection file or a covenant enforcement file is turned over to us is, again, we're going to do a title search. We're going to do the bankruptcy search. We're going to do a public trustee search, just like in a collection file. And then we're going to send a demand letter to the owner. That demand letter is going to advise the owner what the violation is. It's going to tell them what they need to do to cure it, and then what's going to happen if they don't cure it. So if they need to paint and they need to submit an ARC request form, something along those lines, we're going to let them know that. We're going to give them the 10 or 15 days to get that done. If they don't, then we're going to move forward with either a second letter or a lawsuit. Covenant enforcement lawsuit. So the first thing we're going to do is draft a lawsuit for injunctive relief. Again, asking that court to issue an order saying that the owner has to comply with the covenants. That will get filed. There'll be a return date with the court, and just like with a debt recovery file, the owner will either show up or they'll file the answer. If an answer is filed, just like in covenant enforcement, we'll move forward with mediation settlement. When we are talking with mediation here, we oftentimes will try and get a global settlement. So we will realize that they are owing not just attorney's fees, but also attorney's fees, fines, any other amount that's owed. So when I'm at mediation for a covenant enforcement lawsuit, I want to expand that scope to include everything that's owed. So if the owner owes maybe $2,000, $2,500 in attorney's fees, but also owes another $2,000 in fines, late fees, interest, etc., I'm going to try and get them to enter into a settlement for that full amount, for a payment plan for the full amount. Then I'm also going to require that they bring the property back into repair. So as of right now, most associations are going to say, look, we'll enter into a settlement, we'll give them a payment plan, and the property needs to be in compliance by May 1st, because most people aren't enforcing covenants right now, especially like the landscaping issues. So we'll get that written up. They'll have the payment plan there. They will have the agreement that they're going to have the property completed by May 1st. If they fail to do that, we now have a settlement that's been signed by both parties. It's been made an order of the court. And if they fail to comply with any of these things, we now simply file this with the judge, and the judge will now give us the total amount owed in the settlement. So we've now skipped the need to go forward with a collection lawsuit because the owners already agreed to that in terms of the settlement. So that's the benefit of mediation and settlement, is we have the ability to expand the scope and more than just what our complaint is asking for. The other thing that we're looking at when we're doing these settlement is, again, just like with the collection case, oftentimes we're going to use those soft costs as a negotiating tool to try and get the owner to enter into a payment plan so that we can, again, collect the money as fast as possible, as well as get the property taken care of as fast as possible. If we aren't able to settle a mediation, just like with collections and with foreclosure, we're going to then have to get prepared for trial. Covenant enforcement is going to have a little more in-depth than collections, not quite as much as a foreclosure trial, but we are going to need to be going over the exhibits. Again, with all covenant enforcement, pictures are key. So when you guys are doing your drive-throughs and things like that, or if it's just someone complaining, try and get pictures. We need to have date stamped pictures as much as possible so that we can present that to the court to show that here's when the property fell into disrepair. Here's 2 months later when we sent the first courtesy notice. Here's 2 months after that, or 30 days or 15 days after that, where we sent the fine notice, and we can show them that the property looks the same through all these pictures. Makes our case much better, makes it much easier for the judge to understand what is going on. So that is always a great thing to do. You can't have enough pictures. Try and have them, as many of them as you can. We'll then go through trial. Presuming that we win at trial and we get the judgment obtained, the next thing that we're going to do is twofold. So this is where things can kind of diverge a little bit. If the owner has still not fixed the property once we have judgment, the next step that we're going to do is we're going to serve the owner with that judgment. We're then going to request a contempt citation. So ultimately, this is the court now issuing a citation saying that the owner has not complied with the court's order. The judge doesn't really care that the owner hasn't fixed the property. What he does care is that the judge issued an order and this defendant has now not complied with his order. So we'll issue that citation, we'll serve it on the owner, and then we'll have a contempt citation hearing. In this case, the owner will come in front of the judge. The judge will ask him to explain why he has not complied with his order. The owners typically don't have any good reason other than they say that it's unfair, yada, yada, yada. The judge, however, is going to be relatively angry. He's going to give the owner on this first time probably a slap on the wrist. He's going to say, look, I have the ability to throw you in jail for not complying with my order. I'm not going to throw you in jail this time. I'm going to give you a reasonable amount of time. Maybe it's 15 days, maybe it's 30 days, depending on what the violation is, to come in compliance. If you don't come into compliance and you have to be hauled back in front of me again, I am likely going to slap you either with a large fine or put you in jail. It is very rare. I've only had it happen once where an owner who has been pulled into a contempt citation hearing has failed to complete the work within the time frame required by the court. So once we get them in there, it is very likely that the property is going to come to compliance very quickly. So that's the usual process that happens in terms of the contempt citation. Once we have the property in compliance, we're then going to hand this over to collections so that they can go collect any fines and legal fees that the owner has not paid. That will mean that they will file a new lawsuit, they'll go after it, and they'll go through their normal processes like we've already talked about. If the owner does not come in to compliance, maybe we can't get them served, we can't get a contempt. When we are getting our order, we will also put in there that the association has the ability to go into the property and fix it itself. Now, self-help is very uncommon. We typically advise against it mostly because it's kind of a pain in terms of we're not going to recommend you go onto the property unless the property is vacant or you're going there with law enforcement. So it's hard to get, especially right now during COVID times, to have law enforcement come with you to sit there for days, if that's what's needed, to install landscaping or to wait for a house to be painted, etc. So while self-help is an option, it's usually pretty rare and we don't use it very often. But boards talk about it a lot, and it is an option. But before you do it, make sure you talk to your attorney and let's walk through the actual steps of how we want to do this and what makes most sense in this specific stance. Maybe it's something as simple as they have a bunch of clutter in their yard, and all we need to do is have law enforcement present as we go on and remove that pursuant to the court order. And that might make sense to have self-help there. If it is the owner has installed a hot tub without approval, and we're going to have to go rip it out, it might not make as much sense to do self-help there. It might make more sense to go through with a contempt citation. Or if we can't get it done that way, maybe now we move on to a foreclosure and just get this person out of the community in general. We do have a question here from Jody. Do written witness statements work as well as photos for covenant violations? So from the strictly legal sense, sure. A written statement would work because we would have that written statement. We'd also be calling that individual as a witness. So we would call them up there. They would have the ability to be cross-examined, etc. So can they work? Sure. It is much easier, however, to have photo evidence. So if we have the manager who has taken a bunch of pictures, they're already going to be on the stand anyways. And all I have to do is show the court, here's what the property looked like on January 1st. Here's what the property looked like on February 1st. Here's what the property looked like now on June 1st. We didn't file the lawsuit until July 1st, and the property still looks like this. It's much easier for a judge to look at that and not have to judge the credibility of the witness and say, nothing has changed from January 1st to July 1st. The association had no option but to move forward with this lawsuit. So it's much better if we have pictures rather than just relying on written documents. Hopefully that answered your question. Covenant enforcement, we also have some other postings that we can use. Depending on what the violation is, we might be able to rely on the health department or zoning department. Maybe it's law enforcement, fire department, all these things that are listed here, depending on what the violation is. Sometimes we can rely on the city or state to come in and do some of this work for us. So if whatever the violation is also a health violation, maybe it's hoarding, something along those lines, we might be able to call in the health department, we might be able to call in the fire department to come in and try and deal with this problem. That's always a great way to look at it. And it's inexpensive to the association. So that's one way that we also look to try and deal with some of these post-judgment issues. There's also internal resources, just like with collections. Maybe we can suspend voting and see if that will get someone to come into compliance. I mean, suspending voting, unless they are very angry and trying to get on the board, doesn't usually have a huge impact. Again, suspension of the pool or rec center is a great thing. Shutting off garbage collection or turning off utilities typically are not something we're going to advise. One, it's going to make the problem worse because now this person's just going to have garbage collecting on their property. Two, we don't want to be turning off someone's electricity or heat during the wintertime. It just leads to bigger issues. One thing that we have found in condos or places that might be providing internet, the ability to turn off someone's internet, if we have the ability, is a great thing to use because everyone needs it. Everyone uses it these days. So it's a great way to get people to come to the table. So that's possible. Towing is one of the quickest ways for the association to get sued. So before you do that, make sure you're communicating with your attorney so we can kind of walk you through the steps and determine if that's the best approach. And then we already kind of briefly talked about self-help. So with self-help, one, you have to make sure, does the declaration have authority? Do you have authority to do it? When do we want to use it? Again, we already talked about we only want to use it if it's vacant or if we have law enforcement there. Always make sure before we're going with self-help that the attorney's involved and walking you through the steps. We want to do it as quickly as possible, and we want to make sure we're causing no damage. So oftentimes we're going to recommend that you have someone there videotaping whatever's going on so that an owner can't come back and say, while you were doing this, you destroyed my lawn, whatever it is, you broke such and such, this priceless gift that was from wherever, or someone stole something. We always want to make sure that we have video evidence to show that none of that is taking place. So the last kind of subset of files that we can talk about are our general litigation files. This is very broad. So this could be anything from insurance defense, where maybe there's a slip and fall on the property. Maybe it's a small construction defect matter. Maybe we are having to sue your landscaping vendor because they're not doing what they're supposed to do. Maybe the landscape vendor is suing you because the association hasn't paid. So there's a wide range of what's going on. The first thing we need to assess is the association being sued or is the association the one suing? If the association is being sued, then we need to determine, does insurance make sense? Does it make sense for us to submit this to insurance defense? If this is a claim for $5,000 and we have an insurance deductible of $3,000, it might make sense to submit this for insurance so that the association's only paying $3,000 in attorney's fees, and everything else is going to be borne by the insurance company. If the association has a $10,000 deductible and the association's only being sued for $5,000, it might not make sense to submit it to insurance. It might make more sense for it just be my firm to handle it. So those are things that we're going to look at ahead of time. The process for the lawsuit is similar to foreclosure and the other files that we've stated before, depending on whether we're in county court. So it might be more similar to a covenant enforcement or a debt recovery file, or if we're in district court, it might be more similar to a foreclosure file. With each progressive court that you go up, so if you go small claims court, county court, district court, and then if we get to federal court or something along those lines, or appeals, the cost is going to go up with each court that you're in because the timelines are different. The amount of work that goes in is certainly different. So the cost will go up with that as well. So depending on who the opposing party is, will determine what kind of remedies we have. So once we've gone through all those steps that we've already talked about with the other files and say we have a judgment, now it's going to be, how are we going to collect on this judgment? If it's an owner who's suing the association, then we might be able to rely on the declaration. And if that's the case, we might be able to use a wage garnishment or a bank garnishment to collect the funds. If it's not an owner, say it's a vendor, who is the one who's suing us, then it gets a little bit different. In those cases, we don't have the declaration to rely on because these people aren't subject to the declaration. So at that stage, we have to find assets of this company or entity that we're going to try and deal with. Oftentimes what we'll do in these kinds of situations is we'll file what's called a transcript of judgment. This basically works as a lien on all of the properties that the defendant owns or whoever we have the judgment against owns. So in that county. So if this person owns a bunch of property in Adams County, we'd file a transcript of judgment there. And that's going to encumber every property that they own in Adams County. So if they try to sell one of their properties, before they can sell it, they're going to have to satisfy our judgment. So it's a great tool, especially if we're dealing with a declarant or someone who owns multiple properties. It's a great tool that we can use to try and put some leverage on them because it ties up their properties. Other things that we might have to do is we may need to perform a debtor deposition. So ultimately what this is we file paper with the court. Whoever the party is then has to send a representative, and I get to go depose them. I get to ask them financial questions like in interrogatories. I get to ask them questions about different property they own that we might be able to attach to. So it's a great tool when we're having to deal with these types of entities. Obviously with these things, it raises the cost because I'm having to go, one, file additional paperwork, but two, I now have to go depose someone. And so it certainly raises the cost, but it will hopefully provide us with assets that we can then attach to and collect for the association. Another choice, depending on who the defendant is foreclosure may be an option. Maybe we're foreclosing on our judgment lien. Maybe if it's an owner who's coming against us, maybe foreclosure is the quickest way for us to collect from them. So again, foreclosure is another great tool in litigation files to go ahead and collect our judgment. So there's also other things that might happen in any given case. We've already talked about arbitration, mediation. So mediation is going to be required in almost every case. Arbitration may be required. The difference is that typically mediation is going to be non-binding. So if nothing happens at the mediation, so be it, we move on to trial. The difference is with arbitration is you may be in front of one person, you may be in front of three people, but they have the ability to basically serve as the judge and issue a binding order. So that's the main difference between arbitration and mediation. Arbitration is typically going to be much more expensive. We tend to try and stray away from arbitration unless we're required to. We'd rather have a judge hear it than a panel of individuals. Costs, mediation is so prevalent nowadays because the cost is relatively small. Most of our mediations, if we're talking collections, foreclosure, debt recovery, collections, covenant enforcement, those are going to be typically small mediations. You're talking maybe 2 hours of actual time at the mediation, a couple hours to prepare for. So it's relatively small. If we are dealing with a foreclosure or a big litigation case, it might be a week-long mediation. So it just kind of depends. But those are good tools to try and keep the costs down for the association and try and see if we can't reach a settlement. And ultimately, again, what we're trying to do is get money in the door as fast as possible for the association. Mediation is oftentimes one of the easiest ways to do that because we can get the owner in front of a neutral third party who typically, in most of these cases, is going to understand that the association is likely in the right. And so they're going to lean on that owner a little bit to try and get into a payment plan. And so that's one of the best ways that we can get people paying the association money. In terms of just kind of general defenses that you're going to see, we're going to have challenges to the covenant, the rule or guideline. Oftentimes, especially right now, they are challenging the board's authority to adopt a rule or guideline, or they're saying whatever the board has adopted is in violation of the covenants. And so that's a big thing that we're seeing right now. We're also seeing a huge increase in people challenging the procedure that boards are using, as well as the decision process. I think boards have gotten very used to no one really challenging what they're doing. And so they've sometimes slipped on following their adoption of a rules policy, or they're not following all the things that are in place that they're supposed to by statute. And owners are jumping all over that right now. And they have plenty of attorneys that are willing to file lawsuits challenging these processes. So we have lots of lawsuits going on right now where an amendment has passed and an owner has hired an attorney. And now that amendment is being challenged in court. And so we're having to go defend the association. And if the association hasn't followed the proper processes, that's a real problem. Now, we are always trying to guide the associations along with the management companies to follow the proper process, but it doesn't always happen. And so that's a big issue of what's going on right now. Abandonment will sometimes come up in terms of if the association hasn't enforced something for years and everyone in the association is doing it, you might see an argument that the association has abandoned that covenant. There's a new case out of Texas from last year that has put a little more teeth in the abandonment argument. We don't have anything really in Colorado that addresses it. But it is an argument that you see a lot of people bringing up. Waiver falls into the same thing, that the association has waived its right to enforce because we haven't enforced for so long. Latches and estoppel are equitable defenses, which basically kind of go along the idea of similar to waiver and abandonment, where you haven't done something for so long that you're now stopped from being able to enforce it. There's also the argument of estoppel comes up where an owner submitted something to the association maybe never acted on it or approved it, and now a new board's in place, and we are trying to say, no, this is actually a violation of the governing documents. In that case, they're going to make the argument that the association is stopped from being able to bring that up. Selective enforcement is one that they're always going to bring up. I rarely, if ever, see a court really buy into that argument. It can certainly weaken our defense a little bit, or our argument a bit, but I'm never too worried about the selective enforcement. Typically, you guys are enforcing these in an even manner. You don't know who's living where. You see a violation, you enforce the violation. Statute of limitations, again, just as a reminder with every class that I do, on those building requirements, things that are physical, so say someone added a roof or put in a fence, you have 1 year from the date that those items were installed to bring your lawsuit. So make sure you are aware of that. Does look like we have another question. This is from Mary. During these lengthy processes, is there a way to placate the other owners who might be directly impacted by the violations, i.e. in multiplex buildings? So the short answer to your question, Mary, is no. We have to go through the process, and the court process can be lengthy. Now, we can certainly be informing the membership that we are going through our process and advise them that all of these court cases are public record, so they are more than welcome to go down to the courthouse and request documents, and they can see exactly what's going on in the case, and they can see that we are proceeding forward. But in terms of, we don't have anything that we can really preemptively do to stop this until we have that court order. So that can be obviously frustrating to owners, especially if this is my next door neighbor and their yard is now all dirt, and they don't see us do anything. The best thing that we can do is be communicating with the community to advise them that, yes, we are taking every step that we can. We are enforcing against everyone that has a violation. We're going through our enforcement policy, and we're listening to our attorneys, and they are advising us of what we can and cannot do. And we are following all of that advice and going through those steps. Let me see if there are any other questions. So it does not look like there's any other questions that I see at the moment. We have 3 minutes. If you guys have any questions, I'm sitting on here for now 2 minutes. So if anyone wants to type in a question, I will certainly answer that. If not, I will sit here in silence with you guys for 2 minutes. No, so ultimately, again, I think one of the biggest things that we need to be focused on with both our boards and attorneys in terms of the management companies, we need to be setting the expectation of that this is going to be a long process. It's not a quick process. There is no quick fix. So if we go into the boards explaining that to them, the board is not wondering 2 months into the process why we haven't gotten anywhere. So one thing that management companies can certainly help out with the attorneys with is managing those expectations of understanding that this is a process, as well as the attorneys making sure we're putting that in writing to both the management companies and the boards. And maybe we need to come to a board meeting if that would make sense for the boards to go out there and go ahead and explain that to them and walk them through what this process is going to look like. We do have a quick question of all court cases in settlement, or I guess are all court cases and settlements public record, have to be confidential. So a settlement does not have to be public record, likely won't be public record. However, owners are entitled to all contracts that are entered into by the association. So oftentimes we have people associations wanting this to remain private. Unfortunately, written into those confidentiality clauses that might be in the settlement agreement is going to say that if there is a law or tax reason that requires this disclosure, it's going to have to be disclosed. And one of those disclosures is under Kiowa and presumably under your inspection of records policy, is that all agreements of the association are subject to inspection. And so that is something that would have to be turned over if an owner asked for it. So the short answer is it's unlikely that you would be able to keep it confidential, a settlement, but you don't have to be out there throwing it out to the world. But if an owner requests it, they should be given it. So a quick question. This is a lot to know. How do managers not get accused of practicing law? Look, it's always a fine line that managers are walking. Ultimately, if you're drafting any legal documents, that's practicing law. If you are simply relaying what the association's attorney has informed you, that should not be practicing law. So again, rely on your experts, which are the attorneys, to provide you information, and then you can relay that information, be that conduit of that information without running the risk of practicing law. So another question on confidentiality of settlements. Again, when you're dealing with insurance defense, oftentimes they will want to put in these confidentiality clauses. That is oftentimes a lack of their knowledge in terms of what is required under Kiowa. And it's something that, look, there is a way for individuals to get this information, and the association likely will have to turn it over if it's requested. Quick last question. When does 1 year for the architectural violation start? For example, if the construction is in the backyard 2 years ago, and the association did not know about it until a neighbor reported it. So this is a common question. The statute specifically reads that it's 1 year from when the association knew or should have known of the violation. The issue with should have known is that if we are going to court and we're arguing over the statute of limitations, and we spend our whole entire first part of the trial arguing that there's no way that the association could have known about this violation because it's hidden in the backyard. The only way you can see it is from the third floor window of the neighbor. We've now, and so there's no way that this statute of limitations could run because we didn't know about it. We've now spent our entire first part of the trial arguing that it's impossible for us to see. The second part of the trial now is trying to explain to court that although no one can see it except from this third floor window, this is a huge issue, and you now need to require that this owner take it down because it's a problem for the association. Well, we've argued against ourselves that entire first part of the trial because it's not an issue. It's only an issue to one person. They can see it from the third floor window. So it really works against us. So the kind of rule of thumb that we use is basically it's 1 year from the date that it's installed. So if this is painting or if this is roofs or something like that, that's open and obvious. Everyone would have the ability to see that. The fact that you didn't notice it for a year is irrelevant. So the short answer is we're typically going to rely on that first date that it was installed, not necessarily the date that it was observed. So with that, thank you guys very much. I appreciate it. If you have any questions, feel free to email me. Otherwise, you guys have a great rest of your Wednesday. Take care.